joined with an excellent panel, Michael Cardello and Merrill Hurt. And we're going to talk about court appointed neutrals. What we used to know earlier was the special masters and those appointed by the courts and or by arbitrators, mediators. We're going to talk about some of the pros and cons of this and how it is growing in this area. What I would like to do is have each of the parties briefly introduce themselves, and then we'll get started. Michael, if you want to go first, please.
Sure. I'm Michael Cardello. I'm a managing partner of Morit Hock and Hamroff in Garden City. We have offices in Manhattan as well as Fort Lauderdale. I'm a commercial litigator by trade. I've been at this firm for almost 30 years. And a big part of my practice is working as a neutral, court-appointed neutral, whether as a receiver or as a mediator, but particularly as a special referee, as a designated in New York, working on discovery issues for parties that just can't get along.
Yes. Merrill.
Hi, I'm Merrill Hirsch. I've been a litigator for over 40 years and litigated in over 40 states, but now most of my time is spent as an ADR professional. I'm an arbitrator, I'm a mediator, I'm a hearing examiner, and I'm also the executive director of the Academy of Court-Appointed Neutrals. And I live in Washington, D.C.
Excellent. And as I said before, Michael Koppel. Our firm focuses on complex business valuation and financial forensics. And we also get involved very often, especially with regards to bankruptcies, more than other areas right now, with regards to being a court-appointed neutral. Maybe we can start off with the basic 101. And Merrill, if you can define what you perceive as a court-appointed neutral.
Sure. Best definition of a court-appointed neutral is a Swiss Army knife. Think of it as someone brought into by the court to help the court with dealing with some problem. The most common example that people think of is the judge pulling his or her hair out in frustration at the parties and saying, I'm tired of you. I'm sick of these motions. I want to send you to your mother. Court-appointed neutral Michael, come here. Okay. But it can also be someone appointed to monitor a decree to make sure it gets implemented. Could be somebody appointed to allocate money to victims, like the 9/11 fund wasn't a court-appointed setting, but the basic ideas of allocating to victims apply in court-appointed settings too. Could be an expert, someone to tell the judge what's junk science in these expert reports, or a forensic accountant to figure out where money went from a trust, or more to the point here, a business valuator to help with assessing the value of a business in connection where that's an issue in litigation, commercial litigation or divorce or bankruptcy or some other setting. It could be it's used in criminal proceedings, somebody to go with the parties with the law enforcement to execute a warrant of the law office to make sure that they don't see attorney-client information, perhaps appointed to review the adequacy of a government Brady disclosure or anything like that. Basically think something that might be of use for having a neutral to make the litigation faster, less expensive, or better informed.
Michael, are you seeing the role of the court-appointed neutrals increasing in the last couple of years?
Yes, I've been doing this as a court-appointed neutral probably close to 15 years, maybe even longer than that. I would say 17, 18 years. And during that period of time, it has increased dramatically. The resources of the court system, particularly in New York, have been reduced. The court dockets have increased. And the complexity of the cases, particularly in the commercial divisions of the various counties, are complex cases with a lot of parties. And courts just don't have the resources to handle the myriad of discovery disputes. I come in and handle all of it, soup to nuts, get the case ready for trial.
Now, is most of your work with the federal environment or with the state?
No, in the state, most of mine is with the state court. In New York, you have various courts called the commercial division courts that allow business disputes to be heard by particular judges. Depending upon the county, there's a different number of judges in those particular commercial divisions. Those are the most complex cases. For instance, in New York County, there are 8 commercial division judges, and they hear some of the most complex cases with the most amount of parties, with a lot of issues. And so the court system does need assistance, and I'm there to help the court make this process, at least from the perspective of the discovery portion of the case, run smoothly. Those issues don't reach the court as often as they would because I'm there to resolve the disputes.
And how do you go through the process? It's your quasi mediation, isn't it? Trying to appease people, or if there's a disagreement, you just go with your professional opinion or that of your team.
So it's very different than mediation. I do a fair amount of mediation too. In this role, it's more of a quasi-judicial role where I'm actually deciding issues. So everything, there's no ex parte communications. I have to adhere to the judicial ethics. So it's very different than mediation, although I always try to get a consensus to try to work out issues before it goes to the next level, which for me, I usually have the parties after meet and confer and then conference with me, have them send letters to me to see if I can resolve it at that point. There are times when I need to have full-blown motions made to me, submitted to me, and then I'll decide those motions. And that's how my process to make this as much smoother process for the parties and the court.
Merrill, is the difference significant between states? Michael outlined the process for the state of New York, but is it different, various between the 50 states and the territories?
Yes, it varies. I mean, the basic idea is the same. One of the things that we're working on both at the Academy of Court-Appointed Neutrals and also at the American Bar Association is to get a better understanding of the job so that you can have a better sense of what, I mean, you start with the name, okay?
Right.
And the name this role is given, there are dozens of them, you know, referee,
Yeah.
monitor, you know, facilitator, and jillions of different names that get used in different states under different statutes or different rules. The predominant rule in state courts is some version of Federal Rule 53 gets adapted into state rules, but that's only that's only the plurality of states that do that, and some of them actually never updated it since the version of the federal rules that were used before 2003, which gives you an idea of how much thought is gone into this. So it varies the states. There is an effort that we've been making to think of creative ways in which to use this that they may never have been used before. Can you use court-appointed neutrals to assist access to justice with self-represented litigants, for example, which is largely a state court problem, and by and large tend to be used more in federal court, but tend to be more needed in state courts. New York is its own, like in a lot of areas of law, its own one-off in some ways, obviously, both because of the huge difference in the state between the courts in the New York City and Long Island and Westchester and the courts in upstate and the types of problems they face, and also because of its history and its sort of one-off setup of civil procedure and various other things, with a lot of different pilot programs mixed in historically that have further complicated the different uses of neutrals. But in every state has kind of its own story about this. Would be a fair statement.
Well, given that background, Michael, how would you recommend if someone was interested and had the skill set to become a court-appointed neutral? What's the process that he or she would have to go through?
Well, the first thing
I might add, in New York.
Well, the first thing you should join ACAN.
Right.
I'll do a little pitch for this organization. The Academy of Court-Appointed Neutrals gives you the skill set to learn if you're just a beginner at it. What is very important is to have that initial skill set. And so by participating in ACAN and going to the meetings and getting involved, you'll learn, and through the incubator program, you'll learn about what you need to do, the skill set you need to have. One of the things that got me noticed was my involvement with the various bar associations. So whether it was the New York State Bar or the local Nassau County Bar Association or New York City Bar, I spoke on many panels over the years, and I showed the folks, both judges and lawyers, that I know my stuff in commercial litigation. And I think over the years, when the need comes up, judges would think of me. So you can't just put your name on a list somewhere. You have to be involved. You have to get lawyers to know you. You have to get judges to know who you are. You to brand yourself as someone who knows what they're doing. And then hopefully you get your first opportunity, and then word will spread. But I think the first and foremost is that you have to get that skill set and be an excellent lawyer from the get-go. That's the first thing you need to be able to do.
If I can add, I absolutely agree with Michael. One of the things that we're trying to do at ACAN is create pathways into the profession that have never previously existed. And once you say that, inherently you're saying we're building the plane while we're flying it, because you can't guarantee somebody that something that hasn't been done before is tried and tested. It's not. But part of what we are trying to do, for example, is, you asked me about states. One of the things about our country is our courts differ dramatically, and there are huge differences in the needs that each court has. So ultimately, while the American Bar Association has guidelines on use of court-appointed neutrals and working for overall rule changes, the implementation of any idea and a model rule, actually, for states to use, the implementation comes down to what the courthouse is, what your local courthouse in your county is interested in doing. And the best way to do that is to try to work locally with people. And the best way to get into the profession is to start with some skill set that helps. Okay, it could be you're a litigator. That's what Michael's talking about. Could be you're an expert on business valuation. That's a type of skill set. Or you have a background in other types of alternative dispute resolution or many others. Okay, get together, sit down with people in the court and people in the bar and other stakeholders and start working on, how might this tool be used here? Could we develop a pilot program that would be of use? One of the things that we push is to try to get courts to set up rosters for a lot of different reasons. One is that gives you a process where people can get vetted, because otherwise, who's this person being imposed on me? If you have a process where stakeholders are involved, they can go, well, we picked the people on this roster, and you could throw a dart at any of them and they'd all be good, is the ideal system. At ACAN, when people become members of our organization, we have them post profiles so that in effect we have a national roster, and we urge people to go to our list. We also have an RFP process, so people who are interested in neutrals can say, do you have somebody who does this? We send it out to the membership. And part of the thinking behind this is, rather than just pick somebody people already know, do a broader search than that, and have parties, if they're asked to come, instead of a judge saying, I'm going to appoint my friend Joe, or a judge saying, get me a name, and a lawyer says, well, who do you know? I know this person, or go to the lawyer in the office next door and ask them. You set up a system where, okay, let's get a list of diverse people with diverse backgrounds who are on this list, who we can choose from, and let's ask the parties, tell me where you looked. So we can do this more fairly, and we can create more opportunities, because anytime you rely on people even if they're wonderful like Michael, you're guaranteeing it's going to be a repeat player. And
that leads me to my next question, gentlemen, is we've been talking about the court-appointed neutrals as it pertains to litigators, specialties, people like Michael, myself, a business valuator. I'm amazed at the other sectors of professionals that are involved in the court-appointed neutrals. I've already worked with an engineering firm that was involved in certain types of the disputes, medical for pharma. The list goes on and on. Could you name a few that people may not even generally think of as a court-appointed neutral?
Oh, well, Go ahead.
In New York, in New York, in the context of being a receiver, I've been appointed as a receiver, court-appointed neutral, to usually in a commercial foreclosure context. So in those contexts, the secondary appointees I seek from the court are accountants, brokers, business, property managers, things of that nature, because I now have to run a building, collect rent. I have to lease up the building. I have to make sure that the building, the air conditioning is working, and I'm a lawyer, so
Right.
I don't know how to do that stuff. So there are opportunities for many others, and there are lists in New York for those types of neutrals, whatever you may be.
Hey, to give some other examples, take it out of the commercial context, okay? You mentioned medical context, any aspect of medicine that involves, different aspects. Tomorrow, we have a ACAN First Wednesday forum with one of our members talking about genomics. When they set up genomes and all this stuff that led to virus stuff. But take it to other things, family law, somebody with an expertise in financial planning, to work with the parties and trying to figure it out, or an expertise in child psychology, or a social worker, or somebody who has expertise in government programs. That became very important in landlord-tenant cases during the pandemic, because you didn't want to send people out in the street in the middle of the pandemic, but you had landlords who weren't getting paid. So somebody who could work with the parties to try to figure out, work out solutions, who also could say, well, here's the panoply of available government stuff, that might help fill some of the gap between the two, to work with some people constructively. Basically, think about any type of case, in the right case, water cases, a water engineer, who can actually, figure out this stuff. That's actually a very common use of neutrals. It could be people, experience in geography. It could be whatever the case manages. People who understand climate change, climate science. Any expertise that comes up in a particular case could be useful if you had somebody who could work with the parties coming from that field of expertise.
Now, do you find in your professional roles, gentlemen, that the mitigator arbitrator is more willing to use a court-appointed neutral than a formal judicial process in the state of New York, for example?
So in New York, in the New York court system, you can't impose, you can't order a special referee upon a parties in a case. You have to get their consent. And so, but the court and smart litigators do understand that the case will move much quicker and more efficiently with those with a special referee in place. So I see it developing more and more. For me, it's the biggest compliment when lawyers involved in a large litigation seek me out without the court saying, hey, you need to think about a special referee. When parties recognize that they need this to move along, that's what the point. One of the things I'm trying to get lawyers in New York to understand is that you don't have to wait till the court is frustrated, annoyed with all these discovery disputes. You should recognize that there is an alternative. That alternative is to use neutrals. And I've been on cases that have lasted years that would still be going on if it wasn't for me working with the parties. Now, I do see more and more of it. I would like to see more, because frankly, there are more cases now than ever.
Yeah.
Sophistication of the disputes are tremendous, and the parties involved are numerous. And what you'd like to have in a commercial division in the various counties is that you have a judge who knows commercial law. You can get these things resolved quickly, because of course the parties involved are businesses, and they're not in the business of litigation. And so what I'd like to see is to have lawyers think about this option more than they do now. we're making some inroads in the court system because of their limited resources, but the lawyers should be thinking about it as a viable tool to get through the process in a more efficient way.
Now that's one of the central tenets of the American Bar Association adopted guidelines I had mentioned earlier. We have a committee in the Judicial Division of the American Bar Association, and I was involved in that committee before I was involved in ACAN. And part of the work there was to take a look at this tool and see, court-appointed neutrals, could we use it better? And a group across the ABA met for 18 months, came up with guidelines on the appointment and use of what we're now calling court-appointed neutrals in federal and state civil litigation. And the central guideline was it should be a regular part of the administration of cases to consider, if the cases are complex or might otherwise warrant it, to consider the use of a court-appointed neutral and consider it at the outset of the litigation. That's a paraphrase of the very first guideline. And, you think about it, that sounds completely unremarkable. Oh, okay, so this tool might be useful, you should consider it. This is front page news, but in fact, the people haven't thought about this tool. It's been around for thousands of years, but people haven't thought about it. And if you think about it regularly when you have cases come in, before you have the 4 jillion motions filed to court and the hair pulling out, you can have someone head off this stuff before it happens at enormous savings to the parties. And the idea of considering it is exactly that. Consider. You don't appoint somebody in every case. You figure out whether it makes sense. And what you do is do a cost-benefit analysis and figure out, are they going to earn their keep, which is what you ought to do. But if you're not thinking about a tool, you can't use it.
One of the challenges that I found with regard to being a court-appointed neutral is too often we're called in late in the process when it's already hit the fan. And I would have said, if you could have brought me in at the beginning of the motions, depositions, or whatever, I can have saved you from going down this ugly path. How do you facilitate or get the attention to do this earlier in the process? And I'm sure you've seen it, Michael and Meryl, that the old adage, if only you would have called me last year, if only you would have called me before this got to this point.
Well, from my perspective, that's an issue, meaning that a lot of lawyers and courts think, hey, we can do this on our own in the beginning. It's not till later on in which the problems arise, it outstrips the resources of the court, and the parties may start to think about it. So often I have to unwind some of the stuff that's taken place before my appointment, which is complicated. And so I'm doing that right now before we met on an ESI protocol that the parties entered into before I was involved that was inefficient, inappropriate in so many ways. I had to redo it, right? So I would like for parties to consider it. It's in the commercial division rules in New York. New York has promulgated its own commercial division rules. There is a rule now in the revised rules that say parties should consider a special neutral, court-appointed neutral during the process of this case. They want the court system wants that to happen. The judges and the parties, I think, are getting more acclimated to that thought process. I think some of the concern is the cost associated with it, but my fees are modest considering the amount of money at stake for the parties and the lawyers and what are being charged per hour by the lawyers that are prosecuting or defending the case. So it's really more efficient to do it from the beginning, because I could structure the whole discovery procedure in a way that's very, very efficient. To have to unwind everything, it takes more time.
Yeah,
I agree, Michael. And the other issue I like to ask both of you is, what degree of power do you see the court-appointed neutrals? And let me give you an example. When we're called in for a business valuation, it's relatively we go through all the analysis and we have all the reports and everything, and it carries a lot of weight in the process if it's done properly and given our background and credentials. When you go through as a court appointed neutral, how much weight, how much power is involved in your solutions or recommendations?
So in the orders that come down from the court where I get appointed, in my view, it's much more efficient to have it where I'm hearing and determining the issues, not hear and report. For me, to hear and report, to do a decision, and then just have it as a recommendation and go to the court defeats the process. So in almost all the orders that I have seen, I have the authority to order parties to do something. Now, of course, they have appeal rights, and that first level appeal is to the sitting judge that appointed me. But the goal is to get the parties to realize that, okay, here's a decision, we have some clarity, let's move forward. But it's very, very helpful for me to be able to so order a decision that I have written to get the parties to do something that I need them to do to move this along.
Yeah, I would say, look, as a process matter, what Michael is saying is really important, okay? You don't want a situation where the neutral is doing a recommendation that's going to sit for 7 months before the court has time to look at it and the parties can ignore it. So procedurally, particularly on discovery stuff, non-substantive determination of the case, but just process stuff. The normal process is that the neutral can issue an order, the parties can seek review of the order, and in the model rule that the ABA generated, it talks about the different types of review the parties could agree on, but generally speaking, that's how the process works. There's also a separate question, which is the practical authority. Okay, to some extent, the authority of a neutral comes from how good they are. Really genuinely and truly.
Yeah.
If this is somebody the parties respect, frequently parties need an answer. Okay, yes, they can take everything up to the Supreme Court, but the problem is they don't have any answer and so somebody has a discovery motion. One side thinks A, the other side thinks not A, and every single other issue will stack up in back of it because, well, I told you I think A's right, and therefore, you can't get this type of information or that type, or we can't schedule depositions because you can't get the documents you want to rely on in your depositions. So all these issues stack up until they get decided. A process that, okay, we're going to have decisions, and by the way, our trial date's going to matter, okay? We're not going to just kick the can down the road on the trial date. We're expecting to follow it because I'm going to work with you to make that possible, right? If the neutral is good, is fair, is perceived to be an honest broker, and the mindset of the case is let's keep this moving, it's enormously effective. A bad neutral is not going to have much authority as a practical matter. Ultimately, you can always seek review from a judge, but what you want is the balance of giving people the opportunity to have review against the fact that you don't just want another layer of proceedings. That's inefficient. So what you want is somebody who's good who can give the case more time and attention than any judge can afford to give it to help move it along at less expense. That's really the model.
Excellent. Gentlemen, thank you so much for your time. And for those viewers, I would strongly recommend for more information is to take a look at ACAN's website. They have all this information out there. And if you're interested in this, as I am, join the ACAN Association. It'll be time and money well spent. Gentlemen, is there anything else you would like to add before we conclude?
Nope, you can just Google Academy of Court-Appointed Neutrals and find out a lot of information.
It's a terrific organization. I do encourage everyone to take a look at the website and join.
Thank you, gentlemen. I really appreciate your time and have a great day.
Thank you.
Take care.